Good morning. I am Father X. A major question many of you have asked me is, how do I introduce evidence in family court? There's a right way and a wrong way. I testified in my custody case 14 times for about 28 hours, and I introduced tons of evidence. I'll give you real-life examples of how I did it in court. But first, let's discuss some legal concepts about how you're supposed to introduce evidence. These are general guidelines, and you should check with your own state's rules of evidence on the correct procedures for your state. Lawyers study this stuff for years, and there can be some technical complexities, but generally, it's easy after you do it once or twice. It's normal for people who don't understand the trial process to try to introduce evidence the wrong way, and then the judge doesn't allow the evidence. When you're speaking in court, you can't say, "The mother tried to alienate me and I have email evidence. Oh, and the mother hit me and I have pictures of my injuries. I can show it to you." That's how normal people talk every day, but judges and lawyers have rules for introducing evidence. In this example I gave, you started talking about two totally different things and didn't correctly introduce the evidence for either one. You're wondering why the judge isn't asking you to see the evidence so he can evaluate it. But the judge is probably thinking, this guy is not admitting evidence correctly, and it's not my job to help him. If he doesn't do it correctly, then I'm going to deny his request. Or maybe you're trying to introduce evidence during a 15-minute pre-trial conference, but evidence is supposed to be introduced during the actual trial. The judge doesn't accept it because now is not the right time to submit evidence. Let's talk about the right way to introduce evidence. Again, this varies by state, so I want you to Google search the rules of evidence for the civil procedures in your state and look up hearsay objections. I'll give you real examples shortly so you can see how it works, and it'll come together for you by the end of this episode. There are two key steps: laying the foundation and authenticating the evidence. Remember that the judge is the most ignorant person in the room. They have no idea what happened in the real world, and they don't know what you're going to give them. So you have to walk them through your testimony and evidence like you're talking to an 8-year-old. Baby steps. Laying the foundation is when you provide the context and background before presenting a piece of evidence. It answers the questions, what are you talking about and why does it matter? It involves testifying that the evidence is relevant to the case, reliable, and admissible. You also explain why this witness is qualified to testify about the evidence. For example, you can't start off by saying, "Your Honor, I want to show you a picture." First, you must describe that you suffered an injury and how it happened. You have to tell them what the topic is about and why it's relevant to this custody trial. And then you introduce the exhibit, like the picture of your injury. Authenticating evidence means testifying that the evidence is what you claim it is. For example, you say this photograph is a picture of your bruised eye after she punched you in the eye, and the picture represents what your eye looked like after she punched it. Only a witness who observed the actual event can testify about the validity of the picture. For emails, you testify that this email does represent the email that you sent the mother or received from her. After you, the witness, lay the foundation, your lawyer will ask the judge if he can approach the witness to show them the exhibit. When the judge says yes, your lawyer will show it to the opposing lawyer. Then he'll give the exhibit to the witness. If you don't have lawyers, you'll go through these steps yourself. And your lawyer says, "Let the record show I'm presenting this item to the opposing lawyer and the witness." Then, to authenticate the evidence, you testify by answering questions like, "What is this? How do you know about this exhibit? Who took the picture? Who sent the email to who? How do you know it's an email from the mother?" For the most part, you'll have personal knowledge of all your exhibits, and you'll introduce them through your testimony. Then your lawyer asks, "Is this a fair and accurate representation of the email?" And the witness says, "Yes." Now it's authenticated. Then the lawyer asks the court to admit this into evidence as Exhibit 1. The other side might have an objection, so be prepared to counter objections. They might object on relevance, hearsay, whether the witness has personal knowledge of the evidence, or because you didn't lay foundation. There's many reasons. Search the rules of evidence on Google. I'll show you some real examples of how I did it, but first, here are some additional processes you need to know. Number 1, if you attach evidence to your original petition, that doesn't qualify as evidence yet, and the judge may not consider it. During the actual trial, when you introduce those pictures, emails, or evidence as an exhibit properly, then it's part of the trial record and the judge can look at it. Number 2, since the COVID pandemic in 2020, more courts accept evidence electronically into the court's filing system, so both sides can see it. But it's not officially admitted into the case until you formally admit it as evidence during the trial. The electronic system just makes it easier to access. Number 3, before the trial happens, expect trial instructions from the judge. If they don't provide any, ask for them. Some key trial instructions are: do we have to provide exhibits to the other party before the trial? If so, is the deadline 1 week before trial or 30 days before trial? This varies by state and court, and you need to know this. If you don't provide them, or you provide them late, then that's grounds for objection and the judge doesn't have to admit it into evidence. Late evidence might still be allowed, but that gets complicated, so just disclose it on time. Judges often instruct the parties that the plaintiff has to mark their exhibits as Exhibit 1, 2, 3, and the respondent has to mark their exhibits as Exhibit A, B, C, to differentiate each party's evidence. Ask the judge how they want this done. Number 4, exhibits must be given to each party in court, not just to the judge. You need at least 3 copies, one for the judge, one for the other party, and one for yourself. Number 5, well before your trial, plan your testimony and link each piece of evidence to the correct part of your testimony. Plan the order of the topics you plan to present and what evidence you'll introduce for each topic. For each exhibit, write the word exhibit on all 3 copies before you get to court to save time in court. But don't write the actual number 1, 2, 3, etc. until you testify and the exhibit is officially accepted by the judge as evidence. Some evidence may be denied because of objections, or you may decide not to introduce a piece of evidence, and you don't want to have to cross out and rewrite numbers. Let's talk about how introducing evidence works in real life. For this first example, at one point, I was testifying about one of the many crazy arguments my son's mother started in our home and her fits of rage. I was describing a specific incident in our home. Strategically, I had discussed with my lawyer that it would help me tell the story in court better if I had a diagram of the apartment my son's mother and I lived in, where I still lived. So I paid a graphic designer friend to come over to the apartment, measure it, map it out, and create a poster board diagram of the apartment. The diagram was about the size of a 42-inch TV screen, so the judge could see it from afar in the courtroom. It was a simple architectural drawing and layout of our apartment, drawn to scale from a top-down aerial view, showing the 2 bedrooms, living room, kitchen, and bathrooms. It wasn't a photograph of the apartment's contents, but just a top-down layout diagram. I was testifying how this argument was moving from one room to another. Then my lawyer said, "Before we continue, Your Honor, I have an item I would ask to be marked as Respondent K for identification. I would ask the court if we can also use the assistance of the stand in the corner." The judge said, "Fine." And they marked Respondent's Exhibit K for identification. Marking it for identification just means that it's being labeled with a unique identifier. And we marked it K because we had already introduced my exhibits A through J. My lawyer asked me, "I show you what has been marked Respondent's K for identification. Do you recognize that item?" I said yes. And then he and I laid foundation and authenticated with these questions and answers. "What is that item?" "That's the layout of my apartment." "Just so we have the record clear, could you give the address?" And I gave him my address. "How long have you lived in this apartment?" "Since 5 months before our son was born." "Have you lived in this apartment continuously since?" "Yes." "To the present?" Yes. When was the last time you were in this apartment? This morning. And is this item a fair and accurate representation of the layout of your apartment as you know it to be? Yes. Then my lawyer told the judge, I offer what has been previously marked Respondents K into evidence. The judge then said, that's granted. Respondents K for identification will be marked Respondents K in evidence. And then we continued with my direct testimony. Let's talk about a second example. The next month, I was testifying about an incident in June where the mother punched me in the eye. She did it while I was packing a bag trying to get out of the house because she had already started throwing punches. There's a lot more to the testimony, but I'll give you the highlights related to the evidence. I testified that we were in our infant son's room and I was standing by the chair. As soon as I got the sense from her face that she stopped her fit of rage, I hunched over the chair to continue packing. My lawyer asked, what happened next? I answered, then the mother took a step forward and threw a right hook and punched me in the left eye while I was looking down trying to pack. Then my lawyer and I went through these questions and answers back and forth. Did you feel the punch? Yeah. When she punched you in your eye, how did it feel? It hurt. Did there come a time when you were able to see your left eye to see if there were any injuries from the punch? Yes. When did you see your eye? That evening, after I called the police, I looked at my eye. What did you observe when you looked at your eye? I had a cut under my left eye from the mother punching me in the eye and hitting my glasses and the glasses cutting my skin. Was this cut bleeding at any point? There was a red blood mark from the laceration. It wasn't gushing and pouring out blood. My lawyer then told the judge, Your Honor, at this time I have an item and I'd ask that it be shown to the witness. I believe the apartment layout diagram chart is the last one, which I believe was K. Now we have L. The judge asked, would you like it marked L for identification? My lawyer said, yes. This is a copy for the mother's lawyer. I have pre-marked the item in the upper right corner with the letter L. The judge said, I will deem it marked L. Show it to the witness. Then my lawyer and I went back and forth on my direct testimony. I show you what has been deemed marked Respondents L for identification. Do you recognize that item? Yes. What is that item? A photo of me the night of June 3. What is L? What do you observe in L? That's me sitting there with a cut under my left eye. Is this a frontal view of your face or some other view? A frontal view, slightly off-center. Does Respondents L fairly and accurately represent how your left eye appeared on June 3 after the mother punched you in the eye? Yes. Then my lawyer said, Your Honor, I move this item into evidence. The judge asked, any objection? And the mother's lawyer said, no. We knew he wouldn't be able to object. The judge then said, the item will be marked Respondents L in evidence. And then my lawyer continued asking me questions about that night in June. And later in my testimony, we used Exhibit K, the apartment layout diagram, to visually show the judge how the mother threw punches in the bedroom, and I retreated to the living room. She followed me and threw punches in the living room. I blocked them and retreated to our son's room. The diagram was crucial in helping tell the story of violence in a way that forced the judge to live in my shoes and understand the reality of what happened in our home. And the picture of my cut eye added credibility to my story, especially since the mother couldn't object or disagree that this was a picture of my eye after she punched it. Here are a couple of tips about evidence. Some family courtrooms are like the Wild West, and rules are ignored. If neither parent has a lawyer, the judge might be less strict about enforcing the rules of evidence. Maybe. But if either of you has a lawyer, then the judge may be stricter about the rules of evidence. Either way, use the proper technique to introduce evidence to avoid giving the judge an excuse to deny your evidence. Here's a tip for submitting email evidence. Assume the mother emailed you saying she's never going to let you see your children again, and you want to use that email to prove parental alienation. But it's a 3-page email with back and forth about different topics. Assume judges are lazy and don't want to read lots of long emails. First, Print out 3 copies of the entire email chain and not just parts of the emails. If you only print out some of the email chain, the other party can object and say, what you're presenting is incomplete and out of context. Next, with a yellow highlighter or with the Adobe software tool, highlight the key details you want the judge to read. The lines showing the email is from her email address and to yours, the date of the email, and the key sentences you want the judge to read. This helps the judge focus on the parts they need to see. You're doing the judge's job for them, and that's always a good idea, instead of relying on the judge to do a good job. In summary, introducing evidence is simple but needs to be done correctly. Strategically, you don't have to prove every statement or allegation with evidence. But since the judge has discretion in who to believe, and family court judges are known to discriminate against fathers, your best strategy is to drown your judge with evidence. Block them from using their gender-biased discretion. Make sure you watch my episode 10 to create your trial strategy. These might be the darkest days of your life. They were for me. I'm making these educational videos to help you navigate this nightmare. If you subscribe, you can get updates when I post more videos. Thank you for liking, subscribing, and sharing with your friends who are in a similar situation. Please support this channel so I can make more videos. You can donate via my YouTube channel's About page using PayPal or Venmo.